Bhatia International to Balco, a legal maneuver transforming the face of Indian arbitration, submitted by Ms. Pritha Chakravarti and Mr. Pritish Sahu. Both the authors are 4th year law students from KIT School of Law, Bhubaneswar. Introduction. The Indian legal system is known for its delays and disparities. It is a known fact that our courts are overburdened with the pending case, and it's almost impossible to provide quick and efficient relief to aggrieved parties. In Bhatia International vs. Bulk Trading, it laid the foundation for an excessively interventionist role of the judiciary in international arbitration, thereby negating the whole intention of the 1996 Arbitration Act. The decision in Balco, though, resumed the principle of party independency and territoriality as under the UNCTRL model law, and brought the laws relating to arbitration in closer compliance with global rules. The alternative dispute resolution in India, mechanism used across the world, effective, faster and less expensive. The four methods of ADR are negotiation, mediation, conciliation and arbitration. The Arbitration and Conciliation Act of 1996 is an act covering domestic arbitration, international commercial arbitration, enforcement of foreign arbitral award and conciliation. It has far-reaching effect on reducing court litigation. It gives more importance to arbitration and conciliation by adding speed and economy to settlement of disputes. The Arbitration and Conciliation Act 1996, an act to consolidate and amend the law relating to domestic arbitration, international commercial arbitration and enforcement of foreign arbitral awards. The necessity of the act, shrinking boundaries and free trade and international commerce have become global necessities. Quick redressal to commercial dispute through private arbitration, settlement of dispute in an expeditious, convenient, inexpensive and private manner, so that they do not become the subject to future litigation between the parties. The scheme of the Act. The Act is divided into the following parts. Part 1, Domestic Arbitration. Part 2, Enforcement of Foreign Awards. Part 3, Conciliation Procedures. Part 4, Supplementary Provisions. Coming to the case studies. The first case is Bhatia International versus Bulk Trading and others. Coming to the brief facts of the case, Bhatia International entered into a contract with Bulk Trading in 1997. Agreement to be governed as per the rules of the International Chambers of Commerce. But Bulk Trading filed a request with the ICC for arbitration. Both the parties agreed that the process to be held in Paris and appointed a sole arbitrator. Though the respondents filed an application under Section 9 of the Arbitration and Conciliation Act of 1996 in the district courts of Indore and Orissa against Bhatia International. Coming to the issue of the case, the main issue of the case was whether Part 1 of the Arbitration Act would apply to arbitration where the place of arbitration is not in India. Now the arguments by the appellants were that the Part 1 of the Act applies to arbitration where the place of arbitration is India. Otherwise, the Part 2 of the Act would apply. Also, they argued that Section 2, Clause 2 states that provisions of Part 1 of the Act do not apply to India where the place of arbitration is not in India. The appellants also argued that under Section 9 of the Act, an application for interim measure must be made before the award is enforced, and also that Section 36 of the Act deals with enforcement of domestic award only. Furthermore, they argued that Section 5 of the Act, that the judicial authority should not interfere except as provided in the Act. Now coming to the arguments advanced by the respondents. The respondents provided that if the parties by their agreement excludes provisions of Part 1, then only it will not be a part, otherwise it would apply to all international commercial arbitration, including those that take place outside India. Now coming to the judgment, the Honorable Supreme Court said that if the appellant arguments are taken into account, there would be a lacuna as neither Part 1 nor Part 2 would apply to arbitration held in a non-conventional country. It would mean that there is no law in India governing such arbitrations. International commercial arbitration which takes place outside India, then no protection is given to its citizens. The court also looked into the object of the Act, and it said that it was there to establish a uniform legal frame for fair and efficient settlement of disputes. The court also looked into the legislative intent of the makers. Under Section 2F, international commercial arbitration makes no difference between international arbitration that takes place in India or internal arbitration which takes place outside India. Under Section 2, Clause 2 of the Act provides that Part 1 would apply to cases where arbitration takes place in India. To emphasize that the word only not used, hence legislature did not mean that Part 1 would not apply to arbitration outside India. Also Section 2, Clause 4 and Clause 5 defines every arbitration, hence the word every arbitration includes all types of arbitration. The Supreme Court in Bhatia also said that the Act does not appear to be a well-drafted legislation. Therefore, the High Courts of Orissa, Bombay, Madras, Delhi and Calcutta cannot be faulted. In the view of the matter, the court said that the appeal was dismissed. Now coming to the consequences of this decision, the foremost consequence of this decision was that the Part 1 of the Act will also apply to all commercial arbitrations where any one of the parties is Indian. Also going by the judgment, the provisions of Part 1 would apply to every commercial arbitration proceeding where any one of the parties is not Indian, unless the parties by an agreement, express or implied, exclude all or any of its provisions. This judgment of the Supreme Court was widely criticized in the international law community. It said it is an erroneous interpretation of the Act. Party autonomy was rendered useless. The enforcement mechanism has been rendered inefficient, clumsy and uncertain. Now coming to the next case, that is of Balco, Bharat Aluminium. Now the brief facts of this case. There was an agreement between the parties that had stated that the settlement of any shall be governed by the English arbitration. The dispute was with respect to the award passed in international commercial arbitration held outside India with its subject matter and its assets. The Part 1 and Part 2 of the Act are applicable to different fields. The Part 1 of the Act is applicable to all domestically rendered arbitration proceedings that include arbitration proceedings with no foreign party or arbitration proceedings with both foreign parties but held in India, or international commercial arbitration proceedings that are held in India, though Part 2 of the Act applies only to enforcement of foreign hours in India. Seat of arbitration or place of arbitration are used interchanging, but the seat shall remain in the place mentioned in the arbitration agreement. The venue for arbitration might change, but the seat shall remain the same. Also, Section 48 of Part 2 does not confer jurisdiction on two courts to annul the award and is provided only to provide alternatives to parties. Interim relief under Section 9 can be awarded in case of seat of arbitration in international commercial arbitration is India, and thus intervention under Section 9 can be sought only with respect to domestic awards, though Part 2 has no provision that grants interim relief, leading to logical inference that Indian court cannot pass interim orders against awards rendered outside India. Also, Part 1 of the Act shall not be applicable to non-convention arbitral awards. In this regard, many judgments have been delivered relying on Bhatia trading case, and hence the said judgment of Balco shall be applicable prospectively on all arbitration agreements executed after 6 September 2012. Now coming to the conclusion, Balco changed the entire scenario of arbitration in India, but Balco only applies to arbitration agreements proposed into after 6 September 2012. It will take a while for its broad influence to work its means through, as many contracts enter into preceding to this date will have. Thank you and have a nice day.